Good morning, my magnificent young entrepreneurs. Are you ready to learn some law and make some money? And congratulations to making it to the last one of the teaching modules of the semester. You're almost done. Today we're going to talk about business exit strategies. Okay, you've spent years of your life building up a business, but now you're getting old and you want to retire, or you want to start some new and different business venture. You're tired of this one, it's doing well, and you just want to sell it to someone else and try something different. Or maybe the business didn't do too well. How do you get out of it if the business is failing? And finally, if you've built the business up for a lifetime and you want to keep it until you die, how do you make sure you can pass it on to your heirs without the tax man creating such terrible tax consequences upon your death that your heirs are forced to sell the business just to pay the taxes? So that's where we're going today. We're going to talk about the sale of a business. We're going to talk about closing down a business and winding down its affairs. We're going to talk about possible liquidation or reorganization of a business in bankruptcy. And finally, we're going to talk about what's called succession planning, which is how do we pass the business on to our heirs, minimizing the tax consequences so they don't lose the business, being forced to sell it to pay the taxes. So first section of this is going to be on the sale of a business. And of course, the dream sale is you build the business up to where it's so successful that you need huge amounts of capital, and so you do what is called an initial public offering of stock on a nationally traded stock exchange, and you make millions of dollars, and you either stay on to manage the company or you take all the money from your stock sale and you retire to the beach. But that unfortunately doesn't happen with most startup small businesses. That's the rare as a unicorn, some people say. I think a unicorn, though, is a term for people that have successfully done more than one or two or three IPOs. But anyway, one IPO is as rare as a unicorn. So if that doesn't happen, then you're looking at selling your business. Either if it's incorporated, you're going to sell the stock in the corporation. If it's not incorporated, you're going to sell the assets of the business to someone else. And so if we look at a non-stock sale, well, let's look at the stock sale first. If you sell the stock in your small corporation, or you buy a small corporation from someone else, there are at least two major considerations. And one is you want to check the stock certificates, and if possible, talk to the lawyer who set up the corporation to see whether or not there were any restrictions imposed upon the sale of the stock in order to qualify for SEC exemption from securities registration. For example, if the if the SEC registration exemption that they claimed was one that said you can only sell this stock to other residents of the state of California, an intrastate stock offering exemption, and it says right on the share certificate, these certificates cannot be sold to anyone other than a resident of California, and you're coming in from Nevada or Wisconsin to buy the company, you buying that stock may create an SEC registration problem. So you want to check to make sure there are no restrictions on the transfer of the stock. And the second thing is, with regard to selling your corporation and selling the stock to another private buyer, I have seen some of the finest business lawyers in the town commit what I believe is legal malpractice in doing a stock sale where the seller finances a portion of the purchase price. So if you get paid all cash for your stock, you don't have to worry about this. But if you as the seller are, the part of the deal is that you're required to finance a portion of the sales price, and so you take a cash down payment and a promissory note for the balance of the purchase of the stock. Some lawyers will set up the pledge of collateral for the loan, the promissory note, and say, well, your collateral is all the shares of the stock that they just bought, and so if the business fails and they can't make their payments on the purchase of the business, you have the right to repossess the stock certificates, which at that point in time might end up being worthless pieces of paper. Do not take just the stock certificates as collateral for your loan on the sale of the business. If you're going to sell a business and you're going to finance a part of the sale and it's a stock sale, be sure that your lawyer sets up as the collateral pledged for your promissory note all of the hard assets of the business, the inventory, the equipment, the trade name, any trademark, copyrights, patents, accounts receivable, so that in fact you can, if they fail to make the payments, you have a security interest in all the hard assets of the corporation, and you, if necessary, can go to the court and ask for a pre-trial injunction to take possession of those assets or prevent the guy who's failing in the business from selling off those assets before you repossess the business. If all you have is a legal right to repossess the stock certificates, by the time you get that back, all the hard assets of the company may have been sold off and you may get some worthless pieces of paper. So make sure you get the hard assets of the company pledged as collateral and not just the stock certificates. Okay, so if it's not a corporate sale, then there's a concern. If it's a corporate sale, then there's probably some arrangement made with who pays the debts and the old debts of the business. And if no one pays them, then the old debts of the business go with the corporation to the new shareholders. But what about in an asset sale? Well, the law says if you buy all or most of the assets of a business, you're a sole proprietor or a partnership and you're buying the assets of a business, unless you make arrangements otherwise, the debts of that business follow you, the new owner. And so even if the old seller told you that all the business debts were paid off or made arrangements to pay most or all of them off in the sale, it can be that after you pay the guy $500,000 for his business and he retires to the Bahamas, 6 months later somebody else shows up and says, you know, George that owned the business before you, he still owes me $300,000, and if he's gone, you owe me $300,000. Well, that's a big problem for you as the buyer of a business, and there is a way that you can protect yourself from that. It is called the bulk transfer law. Under the bulk transfer laws, if you buy all of the assets of someone's business, what you can do is you can put the cash you're going to pay for those assets into an escrow account, and then the person that's in charge of the escrow account, you and he get together and you mail out a notice to all the known creditors of the business, and you also publish a notice in the local newspaper. This business is being sold. Anyone who has a claim for an unpaid debt or any kind of legal claim against this business, file your claim with the escrow person within the next certain limited number of days. It's usually 30 days to 90 days. And if you don't file your claim within that time, then your claim is forever barred. At least it's barred from making the claim against the new owner. You could probably still go against the old owner if you can find him, if he's not gone off to the Bahamas. So if you do the bulk and then what happens is people make their claims for unpaid debts, and you review those and you either dispute them or you just pay them out of the escrow, and then you know the old debts of the business are paid off. Anyone who shows up later after the time limit, if they didn't file a claim, their claim is barred. At least they're barred from making that claim against the new owner. So you have some protection as the new owner. Now when you go to buy a business, the seller's going to say, oh, I'm in a hurry to get retired and get off to the beach in the Bahamas, and we don't have time to do that bulk transfer stuff. It costs money to do that, and just trust me, I got all the debts paid. Trust but verify, do the bulk transfer process, or else kick yourself in the shins later because you didn't go through the process, and now one of the old business owners' old debts is showing up to ruin your life. So that's the bulk transfer law. Another note about bulk transfer or something related to it. If you are the seller of the business and someone else is buying the business from you, always be sure to send out a written letter to all of your old suppliers and creditors notifying them, hey, I'm selling the business. It's now going to be owned by George Smith. I'm not going to be responsible for any further credit or debts extended to the business. You look to George Smith for payment from now on. And what that does is sometimes the buyer comes in and you have a credit account set up somewhere where you buy product supplies on credit, or you have an existing line of credit at a bank and it's paid off but it's not closed out, and he's having trouble getting credit, and so he takes credit in the name of the business, and the bank lender or the supplier does not know that the ownership of the business has changed, and so they extend credit to the new owner based on your credit reputation, based on their belief that you still own the business because you didn't notify them. And then if the new owner fails and there's unpaid debts, guess who they sue? They sue you as well as the buyer, because they say you didn't tell us that the ownership of the business had changed and we only extended credit to George Smith because we thought you still owned the business. And so they will sue you. They can't do that if you send them a written notice saying the ownership of the business is changing and I'm not going to be responsible for any further debt or credit extended to the business under the new owner. So very important to give them all notice.